Good morning, everyone. We're just going to wait for a few more to get on. All right, it's 10:02, so I think we'll get started. So good morning, everyone. Thanks for joining us today. We're going to be talking about work-related injury today, and with a kind of a bigger focus on the duty disability landscape, just because that's a hot topic right now that has come up, obviously, with the legislature putting through the new bill. So we're going to talk about a few different things, and we should introduce ourselves. I'm Christina Petsulis. I'm an attorney at Flaherty and Hood. And then we also have Paula Maldonado, who is another attorney at the firm as well. We both work in the area of labor and employment and also have a focus on litigation. So we'll get started. So I do want to direct you guys to the Q&A function. So it should be at the bottom of your screen. So please use that for any questions. And then we will either address them as they come up, or we'll address them maybe at a halfway point through the webinar. So please feel free to put your questions in there, and then we'll try to get to all of them. So just a quick agenda that we're going to go over today. So first, we're going to go over the fitness for duty process, and that's just for all employees. We'll speak about, not necessarily public safety focused. And then we'll kind of move into the more public safety focus regarding the duty disability process and para. Then we'll talk about the rise of duty disability claims and kind of see where those numbers are going and look at the future and kind of where things are at this point. And then we'll talk about that hot topic, which is that bill, and then kind of the implications and advice for moving forward. And then we'll get to some questions at the end as well.
Morning, everyone. My name's Paola. Like Christina said, I'm an associate attorney here. I'm going to be talking about fitness for duty. I'm going to be talking about what it is, what the process looks like, and giving you a 10-step process to make sure you effectively administer it. So let's start with what it looks like. What is it? It's a mechanism utilized to ensure an employee at issue is fit to accomplish all essential functions and physical requirements of their duty position. And this is a key tool in assessing approval for leave mandated by laws such as the FMLA. Now, in the psychological context, it is the objective and reasonable basis for believing that an employee, as a result of a psychological condition or impairment, is either unable to perform one or more essential job functions, or they pose a direct threat to their self or others. Now, you got to know when to start this process. So you start, or a public employer will start this process if the employer believes either that an employee has a medical issue based on reports or observations, or an employee or employee's health provider has requested an evaluation. Now, the next part of it, I'm going to give you 10 steps to make sure you administer fitness for duty effectively. These are the 10 steps. I'm going to go into more detail on them. So the first one is going to be to check on the employee. You're going to have to remember to document and retain any observations, any report of this medical issue that may impact the job, and you're going to want to keep that in a confidential medical file. Now, if there's an immediate threat for the health or safety of others, you may have to take interactions between these steps. You're also going to want to obtain sufficient proof of the medical issue. So this person's going to tell you, hey, I have this problem. You're going to want to obtain sufficient proof, and that's going to be an FMLA certification or healthcare provider documentation. you may need to request additional healthcare provider documentation and examination, and you're going to have to ask your employee for permission to be able to obtain this additional documentation. And the way you're going to do that is you're going to write a letter to the employee, and the cover letter is just going to justify your request and what you're requesting. And you're requesting a specific fitness for duty provider or the employee's own provider. You're going to give them the tennyson warning, and you're also going to ask for a consent form to be signed for the employer to be able to obtain and release this information. And the consent is for the provider to release that information. Now, the employee is not required to provide this medical information. And if they don't give you consent to reach out and get additional medical information, then you're just going to have to proceed with this process with the information that you already have available. But assuming that they did sign this consent and you are going to reach out to the medical provider for additional information, you get that information back, we move to step 3. And that's reviewing the medical documentation you get back from the medical provider. You're going to want to make sure that it's sufficient. So you're going to be checking to make sure it describes the nature, severity, and duration of the impairment, the activities or activity that the impairment limits, and to which extent the impairment limits the abilities of the employee to perform the activities or activity. And you're also going to, it's also going to have to substantiate why the requested reasonable accommodation is needed. So you review all of this information. You may still have additional questions. So step 4 is to follow up with the employee, and you can ask them any legally permissible questions, either that of the employee or of the healthcare provider. Now, this employee ends up needing accommodations, or you feel like they may, you're going to move into the analysis for reasonable accommodations. You're going to look at your reasonable accommodation chart and identify the essential functions of this of the employee. And you're going to identify the limitations based on the workplace evidence and the documentation you received from the medical provider. And you're going to identify all potential modifications. Now, once you do that, you move on to step 6, and you're going to discuss the accommodations with the employee. You're going to want to tell them the limitations they have and how they can possibly be overcome based on the list that you created on step 5. So you're going to discuss the request for reasonable accommodation, and make sure that during not only this whole process, but specifically in this step, that you're taking very thorough notes of what you and the employee discussed. Now, once you discuss the possible accommodations with the employee, you're going to notify the employee later on about the accommodations, either denial with reasons or the intended accommodation. Now, if there's no accommodation, then this is where you may consider voluntary resignation for this employee. Now, step 8, you're gonna, assuming you can accommodate your employee, you're gonna move on to step 8, and you're gonna monitor the condition and the effectiveness, and as well as just monitor, take thorough notes of whatever's happening around you, observations that you're making. And once you do that, then you move on to step 9, which is reassess the accommodation duration and any other accommodations that you may have made, depending on step 8 and the monitor of the progress that the employee is making. Now, step 10 is the last step in this process. And this is where the accommodation concludes or the employee requests to return to work. It's going to require a fitness for duty certification, and which is the ability to make sure that they can perform the job functions under their job description. You can consider the full return to work or the accommodation. Now, if the employee actually can't return to work, this is where you're going to consider removal, including the voluntary resignation that I mentioned earlier. with considering benefits. And you would categorize this as a non-disciplinary action, and that's to avoid any labor contract grievance. Now, how can you make this process easier or maybe not even have to go through it? You have to be proactive. So this means that you have to have measures to help ensure that you have a safe and a healthy workplace. This means you have to have procedures, policies, practices to make sure that it's safe and healthy. You gotta coordinate and administer work groups and committees. You gotta conduct health and safety risk assessments. You gotta provide support like an employee assistance program. And LMC has this great PTSD and mental health home toolkit that you guys can look up and see any additional resources there are or other ways to be proactive in this area. Now, I have two questions for you guys that will actually lead into Christina's part. And we just kind of want to gauge where everybody is at on this type of issue at their employer. And you don't have to participate, it's voluntary, but it will help us gauge where everybody's at. First question, and Ping will actually shoot the question out for you, and you can choose yes or no. And so this first question is, have you had to address a mental fitness for duty concern with a public safety employee in the last year? I think hopefully that was enough time to vote, and then Ping can give us the results if she has them available. Nice. So looks like most of you haven't had to deal with a mental fitness for duty concern in the last year, which is awesome. So probably means you guys are being proactive and going through those steps that I mentioned in keeping a safe and healthy environment for your employees. Now, the next question is going to be, if I can get it to move, do you offer any programs or resources for preventative work-related health? You have a yes or a no, and if yes or no don't fit your situation, you don't know, you don't want to answer, you can always get back to me on that and choose C. And the results are yes. Oh, awesome. 85% of you chose yes. That one person said, I'll get back to you. Please get back to me for sure. This is it for my part. I'm sure you're going to realize how these questions fit into Christina's part. Thank you so much. I'll pass it on to Christina.
Thanks, Paola. So yeah, I wanted to pause here for questions just to see if we have any. I have one. Let me just read it really quick. Okay, it's about, so the question states, I heard there's a new workplace law that is requiring employers to provide a space, mental health / PTSD. Is this required for public employers? So I think the law that you're talking about is the one that we're going to get into, the bill that is affecting cities right now related to the kind of mental health treatment that is required. And then, well, I don't want to get in it too much, but that's kind of the preview. So yes, we will get into that. So that's the only question I have right now. So why don't we move forward to the next slide? So we're just going to start really basic with some background information about PARA and the duty disability process. So this is something that, you know, a lot of you might have dealt with before. So obviously PARA is just, you know, an organization that allows public employers and employees to contribute to a portion of that employee's wages, and there's specific funds for that. So there's going to be a police and fire plan, which we'll be mostly focusing on today. But PARA, you know, ultimately they pay retirement and disability benefits to eligible employees And then it's a relevant portion of the retiree's salary at that time. So that's kind of how it just generally works. Go to the next slide. So I did want to pause here and get you guys engaged about, just so I can see how many have actually dealt with this before, just to know how in depth to get, but then just also out of my curiosity. So my question is, how many of you have had a police or firefighter get involved, or sorry, get approved for a duty disability benefit? So yes or no? So go ahead, and I should be popped up on the screen. Go ahead and answer that. Okay. All right. Okay. So more yes than no. So that's kind of what I thought it would be. But I think even for the 44% that said no, I think this is a really good, um, you know, this is good information to have, because, there might be an increase in these cases due to the new law. So that's good. Good to know that a lot of you have gone through it. Hopefully this will be helpful. So just some background on what a duty disability is. It's defined in statute. And it has two parts that we like to break it down into. And that's the first being a condition that is expected to last longer than 12 months from performing normal duties of the position held by an officer or a firefighter. And then the second prong to that is that that specific condition is a direct result of an injury occurring out of the inherently dangerous duties of the job. So those are the two main prongs that we look at in these cases, and that is what para will use to determine whether the officer or firefighter is duty disabled. So I just wanted to give some background on the application on the front end. So what will happen is the employee will apply to para for duty disability, and what needs to be included in that report, it's two medical reports, one from a licensed medical doctor. It's usually the employee's primary healthcare provider. And then another, either a licensed doctor or psychologist, or, the law even allows a chiropractor and some other carve outs for those particular healthcare providers. So those two are needed in there. And obviously they would need to say that the employee has PTSD as a result of their work as a police officer or firefighter. Paula, can you go back one more point on that? So the employer is actually notified of that application. And for those of you that have gone through this, it's just that certification type of form that just has you certify that you're a public employer and that you do employ this particular employee. It gives you a very, I shouldn't be so negative, but it's a pretty vague reason for what the disability might be a lot of the time. So if it's for PTSD, it will just say PTSD. And a lot of times what I've seen is that employers don't really know what has been going on previously in terms of, sometimes it's a shock. They know the employee's been out on leave, but they don't know necessarily the context around this particular disability. So a lot of times employers don't have a lot to say on that form. But we urge you to just write down what you know, but also write down that you don't know if you don't know. So that's the process there. And then para from there will consider the application. So what will happen on the back end is para will send all of those materials in the application. So those medical documents, and then also other things that are in the application, which a lot of times are prepared by a lawyer. And it has a lot of just details about the history of the employer's work, of the employee's work. And then what will happen is a medical advisor retained by para will review those documents and make a determination whether they think it is a duty disability or not. And then 10 times out of 10, usually a para will approve based on what the recommendation is from the medical advisor. So we can go to the next slide. So just some background on also what the benefit actually is. So generally there's two parts to it. One is that if you are deemed duty disabled, you get 60% of your average salary until age 65, and that's paid out of the para fund that obviously the employer and the employee pay into. And then the second part, which is more relevant to us, is that it's a continued health insurance benefit from the employer until the age of 65. So whatever the employer was paying at the time that the employee was injured is what they're going to pay out until the age of 65. So say you're paying $1,000 and towards health insurance, and then the employee is paying $500. So you would just continue with those $1,000 payments, but you would those would be subject to any increases in insurance rates. So if you were increasing those, or if those rates were increased, that would be commensurate with what you're going to pay out to that particular employee. So there is a reimbursement part of this. It was funded way back in the day when this statute first came out. But then that fund kind of dried up, and a lot of times employers aren't able to get that reimbursement just because there's no money left. So a lot of times employers are on the hook for paying these full payments until the age of 65. We can go to the next slide. So we'll just kind of talk about the statistics around the rise of claims and what that looks like. But before we do that, we have a question. I forgot about this question. So for those of you that have had duty disability claims, I'm curious how many you have had total over time. Okay, and if you haven't had any claims yet, just go ahead and exit out of it. I think we can still get the result. Okay. All right. Oh, wow. So we have one. Okay, so one, we have 41%, two, we have 10%, three plus, we have 48%. That's pretty crazy. And that's kind of what I thought it would be. And I can talk about the potential reasons for that. But let's go ahead and get into the next slide, get into what we're seeing in terms of trends. So these numbers are from PARA of what they've reported over the past few years. You can see there's a steady increase from 2019. We're at 118 applications for duty disability. 2020, a big uptick, 241, almost doubled, and then up to 307 in 2021. And then down just a little bit, 257 in 2022. So you can see there's kind of a steady trend that way. So also for more stats for myself, I want to know, what is the average age of the newly hired officers that you hired in 2022? All right, let's see the results. Okay, so 89% of you, 21 to 35. So a lot of new officers obviously coming in, they're young, and you know, that might be an effect. The reason we're kind of asking these questions is kind of to demonstrate and just see, you know, where is the kind of age group of the officers that we're seeing. And so I think that kind of relates to this slide in terms of what the average age of the applicants are. And this is data from 2020 to 2022. So you can see it's within that range. You all are having officers come in between 21 and 35. Well, in a few years, those 36-year-olds end up to 50. We're seeing a lot of them leave the profession by way of duty disability claims. So, and then just a note on that, I mean, looking at obviously, if you have 3+ claims and you have officers that are going out at 35, that's 30 years of continued health insurance benefits for at least 3 officers. That's a huge, huge, huge liability for the city in terms of costs. So that's important to keep in mind. So go to the next slide. Just a little pop quiz for the audience. I'm curious to see what you all think. So what do you think which type of disability has the most applicants? So we got physical, neurological, physical and PTSD. We've seen that one, and then PTSD. Let's see what you guys think. All right, I think that was enough time. Okay, 5% said physical, 2% said neurological, 28% said physical and PTSD, and then 65% of you said PTSD. So let's see what the answer is. Answer is PTSD. I think surprisingly, there's a bit higher number of physical, 16%, which is a decent chunk. Not too many in neurological and physical and PTSD, but you can see, I mean, a massive number of these claims are PTSD. So we'll go to the next slide. And then just looking at kind of the demographics of the duty disability claims. So we're seeing 80% are coming from police officers, 9% from sheriff, and then 9% from fire, and then 2% would be other. So again, a huge number of police officers, PTSD around the age of 35 and 40. I'm sorry, 45. And then on the right side, we have just a little graphic about where most of these applications are coming from in terms of employers. So 38% are coming from Minneapolis, which is huge. I mean, they have a huge police force, but then also they were most affected by the George Floyd murder, obviously. So a lot of claims there. But what we need to keep in mind is other. I mean, that's you all. That's 44%, and that's a huge part of the pie. And a lot of times you all have smaller departments, and you're still seeing multiple officers go out on duty disability. So this is a huge problem for all of you. And so that's why we're hoping to give you some insight. Okay, we'll go to the next slide. So on the duty disability appeal process, so we're going to be talking about the legal standards around that, and then also the actual appeal process, just to walk you through that, what that looks like. So employers can appeal the duty disability determination. It goes to OAH, and then it's really only appealing the health insurance portion of it. So you're not taking away that 60% salary from the employees, but you are contesting the portion that impacts you, which is that health insurance, that continued health insurance payment. So go to the next slide. And again, this is the legal standard again, and this is what will be reviewed at OAH in terms of whether the decision is reversed or not. Again, it's that 2-prong, is the condition expected to last greater than 12 months? And then the second prong being, is that condition a direct result of an injury arising out of the inherently dangerous duties of the job? So a little bit more about the standards and the process. So the burden of proof is on the employer, which obviously makes it a little bit more difficult. It's a preponderance of the evidence, which is a fancy way for saying basically 50% plus one. You need to prove that it's more likely than not that the employee does not have a duty disability. So again, I kind of put that in the second bullet point. Employer must show that when PARA made its duty disability determination, PARA was more likely wrong than right in applying the standard. So there we're proving that the condition was not a direct result of an injury arising out of inherently dangerous duty, and then also that the condition is not expected to last greater than 12 months. So we'll go to the next slide. So just kind of a step-by-step here. So the employer does have an opportunity, obviously, to start this petition to do the appeal, which is going to be triggered by PARA's determination, which will say basically you're on the hook to pay health insurance benefits until the age of 65 as one of your employees is determined to be duty disabled by PARA from XYZ injury. A lot of times, especially for the PTSD ones, it will just say PTSD, exposures to PTSD is considered an inherently dangerous duty. You know, they have their canned language that they put on those. So you'll have 60 days from there. Oh, no, go back, Paula. Thank you. And then so from there, once you do the petition, the case will be assigned to an ALJ at OAH, and then PARA will provide all of those documentations, all of that documentation that I referenced before in the application, so that the employer does have an opportunity to basically provide counter arguments for why the application does not show that the employee has a duty disability. So now we can go to the next slide. And then after that, there will be a pre-hearing conference just to discuss the timelines for discovery. That's an exchange of information, potentially discuss, have a mediation date in there, and then provide a hearing date. And that's the trial type hearing that will have cross-examination and direct examination of witnesses. And that's where you would have a medical expert testify that the employee does not have a duty disability. So within a step in here, you know, there's always the consideration to do a resolution, obviously attorney to attorney discussions about mediation or just straight to settlement. So it really depends on the total exposure. You know, if you have one officer who, you know, the total exposure is maybe only 50,000, which is rare, it's usually way more than that. But if it say it was 50,000, you know, you may want to avoid going through all of this and just reach a settlement beforehand, and then that just lets go of the requirement to pay health insurance until the age of 65, or you could do some sort of continued health insurance type of settlement arrangement. So we've seen that as well. But my one point with this too is that a lot of times cities will need to consider, you know, if I settle one of them, what type of precedent does that set for other officers going out on duty disability? And the reason I'm saying that is because a lot of you said, you know, I have more than 3 of these. So what kind of practice is that setting? Is that incentivizing other officers to go out knowing that they can apply and then just get a payout? So that's something to consider as well. And then the last bullet point here is just that, so proceeding with discovery, again, retaining a medical expert, which is extremely crucial. We would not recommend moving forward to a hearing without that. It's absolutely necessary to kind of rebut the medical evidence that's already in there. You're going to need an expert to rebut that. So go to the next slide. And then, as I said before, the ALJ holds a trial type hearing. Here's the parties' arguments, testimony from witnesses, exhibits, and then obviously closing, and then a post-hearing brief. The ALJ will issue a decision, and then that decision is appealable from either side to the Court of Appeals, the Minnesota Court of Appeals. So it goes straight there. So now we'll get into what I think most people are here to hear about, is the Public Safety Duty Disability Bill that went through this session and what that looks like. So there's 3 main prongs that I would say the bill kind of boils down to. It's the first, which is the mental health treatment requirement for employees before they actually apply to duty disability. The second is the employer required wellness training. And then the third is the funding for the DPS program to administer reimbursement, that 100 million amount. So here's the first one. So the mental health treatment requirement. So officers will be required to go through mental health treatment prior to applying for duty disability benefits. So there's no way for somebody who's alleging PTSD to go straight to duty disability. In terms of application, they need to go through the treatment first, and they're required to do this before obviously applying and getting approved by PARA. It's a 24-week entitlement. 24 weeks leave entitlement, and then the employer is actually required to continue paying salary and benefits while the officers do receive that treatment. There is a reimbursement by the Department of Public Safety, which we'll get into later. But again, that's $100 million. So that's just a one-time sum. We're not sure kind of the the health of that fund over time. So what needs to happen is the applicant, the employee, actually needs to apply for the treatment through para. So basically they need to say, I have this condition and I'm applying to get those, to be entitled to those 24 weeks of treatment. Yeah, they'll do that application, and this is kind of what the application will look like. It actually will include a report by a mental health provider diagnosing the employee with a mental health illness. So I guess I shouldn't just say PTSD. It could be other things, depression, could be anxiety, could be some other things that would affect their work or be, a result of their duties as an officer. Oh, go back one more slide, please. Sorry. And then the documentation from the employer, just certifying the dates that the employee was on duty and covered by the position, will be in there as well. So para will send, once para gets the report, basically that application, then they'll send a request to the employer just to certify, specific information about the employee's employment. Now we can go to the next slide. So this is kind of what approval looks like. An employee who receives approval is not considered disabled unless the employee completes the requirements under the section, receives a final confirmation, and then applies for disability benefits under the same sections that we discussed before. So it's the same duty disability application process. There's just this preceding kind of event that needs to happen, which is that 24 weeks of treatment. Go to the next slide. So this is going back to the approval again. So para must notify the employer of the employee's application within 6 days of receiving it. And then after that, the employer will submit the recertification within 5 business days. And then after that, once para receives that, they will issue a determination after 14 business days. So this is just with regard, again, to the application for the mental health treatment. So I think they came up with these deadlines just to make sure that things move along quickly and don't they don't get drug out throughout time. So here is a synopsis of the treatment. So an employee receives approval, then they will get 24 weeks of treatment for that particular diagnosed mental health treatment before applying for duty disability benefits. The treatment will be at the direction of the mental health professional. And I think I'll probably get a lot of questions about who is that mental health professional. It will be whoever the employee chooses. So it's not someone that you can direct them to, it's who the employee chooses. However, the employer will pay the treatment costs to the extent it's not paid for through the health insurance. So if there's a copay or anything like that, that is the employer's responsibility, but the employers may seek reimbursement from that $100 million fund. Go to the next slide. So treatment required, continued. Okay, so the mental health professional will assess the employee's progress monthly and at the end of the 24 weeks. So I think what this is saying is that after each month, I believe the employer will get a report of where that progress is at, just to know that the employee is continuing with the treatment. And then after the 24 weeks, there will be a period where they're calling it a final confirmation will be done, which is basically a report from the medical healthcare provider, providing an opinion about the employee's prognosis, the duration of the disability, and then the expectations for improvement following the treatment. So that report will come after 24 weeks. And then if at that point of the 24 weeks that the healthcare professional issues that report and the report says, yeah, the employee's making progress and the employee's prognosis is expected to improve with further treatment, then the employee would complete an additional 8 weeks of treatment, also paid for by the employer. And so that would be a total of 32 weeks of treatment. So we'll go to the next slide. So with regard to those that would be fit for duty when they come back, based on what's said in that report by the mental health provider, the employee may return to work part-time or full-time prior to completion of the treatment if the healthcare professional determines that they are medically able to do so. So that this would be if in those kind of monthly checkups, I shouldn't say checkups, those monthly kind of reporting, the medical provider determines that they're able to return to work before completion of that, they're more than welcome to do so, as long as they're cleared by that mental health professional. And then they may also return with certain light duty assignments prior to completion of the treatment. And that's only if deemed medically appropriate by the mental health professional and the employer's approval. So technically you all could say, no, I don't want you to come back, continue with your treatment. So they'll only come back basically before the treatment if you say it's okay. And at that point, the employee is assumed to be fit for duty. So I think I have a little bit more about that here. Yep. So fitness for duty is presumed if basically if they are cleared and determined to be able to return to work under the kind of the requirements of what the statute says. And that's really just up to, I say up to the requirements of the statute, but really that just means that basically the healthcare provider says, yep, they're fit to return because they meet XYZ. But if the employer wants to conduct an independent medical exam, they can do that within 6 weeks of receiving that determination from the employee. I will say I don't think this will come up a lot because I think if you're able to get an officer back to work, it's to your benefit to get them back into work, especially since if they complete this and they're deemed fit for duty, they're not going to be able to go back and apply for duty disability benefits. So I don't think that will come up a lot, but just put it here, just in case in other circumstances where, the employer doesn't feel comfortable with getting the officer back. So we'll go to the next slide. Okay, and now we move into the second prong of what this bill has done, which is employer required wellness training. So basically what the bill says is that employers will only receive that specific reimbursement that I mentioned before for the continued health insurance benefit for disabled officers. So those health insurance benefits until the age of 65, they only receive reimbursement for that if they have implemented a mental injury prevention kind of program. So more details on that next. So this begins January 1, 2024, so this coming January. And so a public employer is obviously just reiterating this. So a public employer is not eligible for reimbursement unless they do one of the following. So either one annual wellness training to peace officers and firefighters who are either employed or volunteers, so it applies to volunteers as well, or an employee assistance program or peer support program. So either one of those two. Which leads me into, I believe there's a question. Yes, there's a question for the audience here. I'm curious to see how many of you offer an employee assistance program already. Okay, see what the results are. Yes, 94% said yes, 6% said no. So that's important because, let's go to the next slide. That is important because you can either do the EAP or the mental health training. So if you already have the EAP, you don't really need to worry about it by January 1, you already have what's needed in place. So these slides are more for the people who don't have the EAP. You're going to either have to do the EAP by January 1, or you're going to have to institute this specific wellness training for police officers, which some of you might want to do anyway. But it's good that you at least have that EAP program in place so you don't have to hurry up and make these changes. So they've kind of put into statute what this wellness training for officers would entail. So it would be really just establishing certain objectives under the training program. So it would be, so under learning objectives in training course, that's under the training board section of the statute. So they kind of relate it back there. Basically creating objectives to prepare peace officers for the stressful and traumatic events that are common to policing and teach officers methods to process and cope with that. So that's pretty much the gist of it. If any of you do need to do this, always consult with us to see how to kind of roll that out practically. We can go to the next slide. So there's this part of it is record keeping is required for this wellness training. So the head of each local, state, and law enforcement agency, so I believe that would be fire chiefs and police chiefs, would maintain written records of the agencies compliant with this requirement. So basically, a written record of the wellness program and what it entails. And then there's, these records are subject to periodic review by the board. And then, so that was for training for officers. So now this is actually training for firefighters. They actually separate them of what's required. So for the firefighters, by no later than February 1, 2024, the Minnesota Fire Initiative will create a training program that then the employers would have to implement. But again, this is only if you don't have an EAP program in place. So if you have that in place, you don't need to worry about it. But if you don't, you may want to do this or just institute the EAP. Okay, now we go into the third piece of the bill, which is the fund appropriation. So it's a one-time $100 million appropriation to DPS, the Department of Public Safety, just like it had done before. I don't know if it was that much, but so same sort of system in terms of reimbursement. But the other things that this fund will cover is the administrative cost to administer reimbursements for the continued health insurance itself. So that money goes to para, right? And then, so that's the first place that it goes. And then the next place that it goes is an actual fund to reimburse public employers. So those reimbursement, again, it's going to be reimbursement for that employee mental health treatment and the salary and benefits. So that 24 to 32 weeks of treatment that you're paying salary and benefits, you're eligible to get a reimbursement for that. And then also any copays or whatever, any other type of treatment cost that wouldn't be covered by the health insurance, you would also be eligible to get reimbursement for that. And then the second part of that is the continuation of health insurance benefits until age 65. If they are deemed duty disabled, you can also get reimbursement for that out of the $100 million. So if after 2024, the account does not have enough money remaining from the 100 million, I don't know if that would be likely, but the way that they will disperse the money is first to cover the administrative costs of MSRS and para, and then they'll cover the payments for reimbursement. So I wanted to break down the costs. We kind of pulled the fiscal note from this bill just to see really how long this money will last, just so employers can plan for the future. So according to para, they have about 20 officers that apply for disability benefits each year. I'm sorry, it's officers and firefighters apply for duty disability benefits each month, and then 240 annually. So if we do the math here, average salary and benefits, we figure is $93,000 annually. That's $7,800 per month. Assume weekly salary of benefits of $1,800, and then assume 5% will not receive initial approval, and 25 weeks of treatment will be reimbursed for 228 applicants. So we're looking at 24 weeks, 1,800 salary and benefits, and 228 applicants. That's about 9.9 million already right there just for 1 year. So let's go to the next slide. And then assuming 100% of applicants will receive an additional 8 weeks of treatment, so the 24 weeks plus the 8 weeks, that's another 3.2 million already taken in the first year. And then assume cost for 24 weeks of treatment will be about 1 million. And then cost for additional 8 weeks of treatment will be about 300,000. So let's go to the next slide. So this is what they had in there of what the yearly cost would be out of that particular reimbursement fund. So they're looking at a grand total out of those numbers that I just went through of 14.4 million, well, more like 14.5 million. And then what they have in here budgeted for, though, is consistent year by year. And that's not really accounting for increases in health insurance rates. It's not looking into potentially the increase in applicants, given that this could be an incentivizing program for more officers to apply. We don't really know which way it's going to go, but they just did a flat rate of what that looks like. But obviously those numbers might go up faster. So go to the next slide. So with regard, I wanted to pause on the cost of that cost there. So for those of you that do get duty disability determinations from your officers, you will have to make kind of that determination of, yes, the fund will cover that health insurance until the age of 65 at this point. But the health of the fund is likely not to be refunded again, above that 100 million. So when it runs out, it's out. And so when you have the opportunity to appeal, we would likely, recommend that you do, just because you will not have the ability to appeal the determination ever again. So even if that money runs out from the fund, you will not have the opportunity to go back and basically fight that determination. So this bill, kind of just makes us look at it on a kind of broad long-term basis, just to ensure that, yes, we're getting the money now, but what about the future? You have an officer that goes out at age 35, you're on the hook for 30 years, but that reimbursement money is only going to last maybe 5. So just kind of keep that in mind when you're kind of dealing with these claims. So that's kind of it for the bill. I wanted to stop for questions, see if we have any. So please put those in the chat. I already have a few. So the first question, is there a limit to the length of treatment covered by the employer? So yes. So the 24 is what they're entitled to. And then if the mental health professional asks for an additional 8, then that's a total of 32 weeks. So it's capped at 32. However, I do believe that officers are able to basically apply for the treatment a few times. I think it's no more than 3 times in 10 years. So I don't know if it could be back to back. I'm not exactly sure. The statute doesn't really speak to that. We'll just have to see and kind of deal with that as we go. But the statute specifically says no more than 3 times in 10 years. And then that kind of leads to the second question. Let me just review it here quick. Okay, so if an individual were deemed fit for duty after going through the lengthy process, wouldn't they be eligible to claim, again, PTSD has returned and will start all over again? Yes, that can happen. So that can definitely happen. But you wouldn't be able to apply for duty disability until you go through the treatment program. So yes, essentially you could be fit for duty, come back after the treatment, but then again, maybe 6 months later, you go back to the treatment and you decide to go out on duty disability. That would be, you would be starting that process all over again. So those are the 2 questions I had now. Give you guys a few more minutes to add any other questions. While I wait for any more questions, we do have our last webinar of this series coming up, Public Employer Workforce and Compensation. And then the presenters will be Rachel Parker, Human Resources Analyst, and then Brandon, attorney at the firm as well. So that's going to be June 22nd, 10 a.m. to 11:30. I think that would be a good one to go to. So I'm not seeing any other questions. Please, please, please feel free to reach out to me or Paola individually to go through anything. I know it's a really massive bill, so I think it's hard to kind of unpack in the time that we had, but if you have any clarifying questions, please reach out. And then we will be providing these slides after the webinar is done. I believe we'll be mailing them out to this, I'm not exactly sure how we're sending that email out. I think just to all the attendees. So we'll be doing that afterwards. But thanks again. Hope you guys all have a great rest of your day. Take care.